All right, it looks like people are still filing in, but I'm going to get started. It's a minute after the hour. My name is Amy Berquist, and I work at the Advocates for Human Rights. When I tell people about my current position at the Advocates for Human Rights, I like to explain that I'm kind of like a microphone for people who aren't heard. My role is to help amplify their voices, to bring the pressure of the United Nations to bear on their governments, including to press their governments to abolish the death penalty. And in that sense, it's kind of like the opposite of clerking for Justice Ginsburg. She had a huge platform and people would be scrutinizing her every word. But in a sense, my role clerking for the justice and my role with the Advocates for Human Rights is similar, because my role is to listen carefully to what our partners in the World Coalition want to achieve, or what the justice wanted to achieve, to collaborate closely with them, and to deploy my skills to help make that happen. My formal position at the Advocates for Human Rights is senior staff attorney, and I've been with the Advocates since 2011, when my clerkship with the justice ended. I am the Advocates point person on the death penalty. I represent the Advocates for Human Rights on the steering committee of the World Coalition Against the Death Penalty, and I am a vice president of the World Coalition Against the Death Penalty. In this CLE, you're going to learn about some of the inherent human rights violations in the death penalty. We'll look at Justice Ginsburg's legacy through her opinions and other statements on the death penalty in the United States. And the Advocates for Human Rights works to abolish the death penalty worldwide. You can support this effort by making a donation. You can simply text death penalty, all one word, no spaces, to 44321, or click on the link in the chat to donate. And we'd really appreciate your support for our efforts. This event is part of more than 100 events around the world this week to mark World Day Against the Death Penalty on October 10th. I chair the World Coalition's World Day Against the Death Penalty working group, so this is a big week for me. And the theme this year, as you can see with the World Day poster up on your screen, is Women Sentenced to Death, an Invisible Reality. And I thought that was particularly appropriate to talk about Justice Ginsburg as the second woman on the US Supreme Court in the context of the death penalty for this event as well. I also want to encourage you, if you do have questions, to use the Q&A function, and I will do my best to respond to them. My colleagues, Katya and Elizabeth at the Advocates, are going to be posting some links in the chat as well if you want to learn more about some of the things that I am talking about. With that, I'm going to pause my PowerPoint and talk on the screen. So Justice Ginsburg was not famous for blockbuster cases. She, I think she's probably rightfully been described as an incrementalist. And what I'm going to focus on in my talk today are some of her opinions relating to the death penalty, and a bit from her speeches, other things she's said publicly that help illuminate her thoughts about the death penalty and how she approached her work. But first, what I think is quite interesting is a little bit about the justice and the death penalty when she was working for the ACLU. And to put this in perspective, we're going back into the 1970s, and at that time, there was a 4-year period in the United States in which the death penalty had been ruled unconstitutional. In 1972, in the case of Feldman versus Georgia, and there'll be a link to that in the chat, the court issued a 1-page per curiam opinion that saying that the death penalty, imposition of the death penalty, constitutes cruel and unusual punishment, violates the Constitution. Then there were more than 200 pages of concurrences and dissents to sort of sort out what the gist was for all of that. And Justices Brennan and Marshall reached the conclusion, sort of took the extreme position at the time that said, in all circumstances, the death penalty is unconstitutional. But the result of this hodgepodge of opinions was that there was what we call a de facto moratorium on the death penalty. And the states that wanted to continue using the death penalty had this direction. They had to remove arbitrary and discriminatory effects of the death penalty in order to satisfy the 8th Amendment. So that was in 1972. Justice Blackmun, and this will be important because I'm going to talk about him a little bit later on, he dissented in Feldman. In other words, he would have wanted to continue to allow the states to use the death penalty. Fast forward 4 years, and another case came out of Georgia called Gregg versus Georgia. We'll put a link to that in the chat if you want to read more. And in this opinion, basically the moratorium was lifted. The Supreme Court said that the death penalty doesn't violate the Eighth Amendment under all circumstances. So opening the door for states to resume using the death penalty. So that brings us to Justice Ginsburg. The following year, 1977, the court was hearing a case called Coker versus Georgia, and we'll put a link to that one in the chat as well. And the question in this case was, does imposing the death penalty for rape violate the Eighth Amendment? In other words, is it an unusual punishment for a crime such as rape? And the American Civil Liberties Union submitted an amicus brief to the court. And in fact, the court concluded on a 7-2 vote in favor of the ACLU's position, and others in favor of Justice Ginsburg's position that she articulated in this brief. And the brief is really interesting. I highly recommend that you take a look at it, because it talks a lot about the intersectionality of race and gender. And it's very interesting in light of this year's World Day Against the Death Penalty theme as well. I do want to offer a warning for people for whom this might be a sensitive subject. For the next 3 minutes or so, I'll be talking about rape. And then I'll show a 5-minute video clip from Justice Ginsburg's confirmation hearing, which that subject is also addressed. So if that's not something that you would like to hear, you can tune out and join us again in another 8 minutes or so. So at the time in 1977, again, this is just after the court resumed allowing states to use the death penalty, there were 3 states, Georgia, North Carolina, and Louisiana, that authorized the death penalty for rape of an adult female. And the argument in the ACLU's brief was that the death penalty for rape should be rejected as a vestige of an ancient patriarchal system in which women were viewed both as the property of men and as entitled to a crippling chivalric protection. So the brief went on to say that part of the fabric of these laws, in fact, hamper prosecution and convictions for the crime of rape, leaving women with actually little real protection against rape. In other words, it's actually a little bit counterintuitive, but to say that having really stiff penalties makes it harder for there to be accountability for crimes of rape. The brief went into some of the history of rape as a crime, not against the person, but as a property crime, that rape was a crime against a man's property, either the husband's property or the father's property, not as a crime against the survivor of the rape. Rape, the view was historically, reduced the value of that property, and the remedies reflected that. So in biblical times, the punishment for rape was for the rapist to pay a bride price to the father and then to marry the victim. That was the punishment. And at common law, the victim could save the offender from death by agreeing to marry him. Our Women's Human Rights Program does work in quite a few countries around the world on gender-based violence. And we've also done work with our program with our colleagues in Morocco and Tunisia, where they, until quite recently, had this similar provision that an offender could escape prosecution for rape if he agreed to marry the victim. And in some cases, the victims were forcibly married off by their families as a way to sort of retain the family honor. And it's really, the issue of marital rape is not something just applicable in distant lands. Marital rape was not a crime in Minnesota until 2 years ago. And we do advocacy with our partners around the world on criminalizing marital rape, which is a common exception to rules that criminalize rape. The ACLU brief went on to talk about the racial double standard of justice. In Georgia, before abolition of slavery, the death penalty for rape was applicable only for Black men. White men could be penalized up to 20 years for rape and up to 5 years for attempted rape. But for Black men, they could be sentenced to death for rape or for attempted rape. And the brief goes on to say that the death penalty for rape has been applied overwhelmingly to condemn Black men for, quote, violating Southern white women. The part of the explanation of the ACLU brief talks about a certain duality regarding women. And this is a duality that is also relevant to the theme of this year's World Day Against the Death Penalty, about how we view women who are at risk of being sentenced to death. First is the duality, the view of a woman as a virgin whose violation inspires outrage. and then the view of the woman as a temptress who threatens every man with a potential conviction for rape. And so because of this duality, a lot of jurisdictions added really severe a lot of these jurisdictions added really severe penalties, like the death penalty, but there are also negative consequences of that were brought to bear, such as rules requiring corroboration of the victim's testimony, rules allowing evidence of the victim's prior sexual conduct or the victim's reputation for chastity, and rules authorizing jury instructions that would impugn the victim's credibility. And of course, all of these consequences had created obstacles to obtaining convictions. They also deterred victims from pursuing charges because they knew that they would be sort of drawn into these proceedings and could create a lot of misery. So that was an important message in the ACLU brief. The court ultimately struck down the death penalty for rape as violating the Eighth Amendment. Brennan and Marshall, echoing what they said in the Furman case, concurred in the judgment, and they said that the death penalty always violates the Eighth Amendment. So this is an opinion we know that Justice Ginsburg would have paid attention to because she was involved in writing this amicus brief. That was sort of the first indication we have in her professional career that she was tuned into death penalty issues. So what I'd like to do now is I'll turn back on my PowerPoint and I'll play a clip from her confirmation hearing in 1993. This is kind of fun to go back in time and see the justice under questioning in the Senate. So bear with me as I get things set up.
Courts are capable of implementing.
Judge Ginsburg, you have declined to talk about the constitutionality of capital punishment. You've distinguished your discussions about abortion from your unwillingness to talk about the death penalty on the basis that you haven't written about or spoken about capital punishment. I hope I understand that that was your answer before. So I want to bring to your attention that during your tenure at the ACLU, you wrote an amicus brief in Coker versus Georgia, and I believe that you wrote that the death penalty for rape was not constitutional. You have written then, haven't you, on the death penalty?
I did not write about the question we've been addressing about the constitutionality of the death penalty. The Coker against Georgia brief was a brief that said the death penalty for rape where there was no death or serious permanent injury apart from the obvious psychological injury, well, that was disproportionate for this reason. The death penalty for rape historically was part of a view of woman as belonging to man, as first her father's possession. If she were raped before marriage, she was damaged goods, and she was not someone. It was a theft of something that belonged first to the father. And if she were a married woman and she were raped, again, she would be regarded as damaged goods. We've seen that most recently in tragedies in many places in the world where women in Bangladesh, for example, were discarded, were treated as worthless because they had been raped. And that was what Coker against Georgia came out of, and that's the whole thrust of that brief, that this was made punishable by death because man's property had been taken from him because of the rape of women, and that was the perspective that was taken in the Coker against Georgia brief.
Again, I'm not a lawyer, so when I refer to something, if you want to tell me that I'm missing a point, feel free to do it. But on page 22 of that brief, a heading underlined says the death sentence for rape is impermissible under the Eighth Amendment because it does not meet, quote, contemporary standards regarding the infliction of punishment and is inadvisable since it diminishes legal protection afforded rape victims. It seems to me it deals directly with the issue of the Eighth Amendment.
Diminishes legal protections afforded rape victims. Senator Grassley, I urge you to read the entire Coker against Georgia brief. I think you will find it to be exactly what I represented it to be. Okay. One of the reasons why rapes went unpunished, why women who had been raped suffered the indignity of having the police refuse to prosecute, was statutes of that order.
Please understand that the reason I brought it up wasn't that I want you to tell me any more than you were willing to tell other people on your position on death penalty. I brought it up because you said you hadn't written on the subject, and I find something here that you have written on the subject.
I've written on the subject of women who have been raped and society's attitude toward them. Coker against Georgia fits into that category, and it must not be taken out of context to say anything about any other subject than the one that was addressed in that brief, and that was that the death penalty for rape, the origin of that and the perpetuation of it was harmful to women, far from resulting in conviction.
Well, let me ask you this then, separate from the whole issue you're writing. Did Coker, outside the fact that it outlawed capital punishment in the case of rape, do you think it solved the purpose that your brief intended to
It
solve?
was a contribution to the proper way to look at this terrible crime. It was a contribution to the end of thinking of women as damaged goods because they'd been raped. That's what I think about it.
All right, so we will continue on, and I think it's fun to see that back and forth and see her expertise. Oh,
Courts are capable.
Sorry. See her expertise on the matter, and it's really quite prescient. You know, she was speaking in 1993, just last year. Bangladesh took steps to approve the death penalty for rape after there were protests about some very publicized rapes. And this is an issue the Advocates for Human Rights got involved with, along with members of the World Coalition Against the Death Penalty. Last year for Human Rights Day, December 10th, we held a webinar on the death penalty for rape in Bangladesh with a coalition member in Bangladesh or an expert from Bangladesh about what the situation was in that country, and my colleague Karen Long, who is a former prosecutor of sexual violence crimes. And Karen was echoing what Justice Ginsburg said in her brief, which was when you have heightened penalties, you actually undermine accountability for perpetrators of sexual violence crimes. So it was really great to hear Karen's firsthand experience and put this all together in that context. So just a little bit of sort of modern day revisiting of what Justice Ginsburg was talking about in her conversation with Senator Grassley. With that, I'm going to stop my PowerPoint again, and we will go back to our discussion of Justice Ginsburg. And so Justice Ginsburg was confirmed by a 96-3 vote. I'm not sure we'll see similar votes going forward with the court. And Justice Ginsburg's first term on the court was 1993 to 1994. One of the things that she likely experienced during that first year that she probably didn't experience as a judge on the U.S. Court of Appeals for the D.C. Circuit was applications for stays of execution. This is something that law clerks really struggle with as well at the court, and the justices do, because these are oftentimes 11th hour applications for stays of execution. And at the court, the weird logic of it is in order to stay a decision of a lower court, you need 5 votes of the 9 justices, but to grant review of a case, you need only 4 votes. So you could have, and there have been situations where you have this macabre result that the court decides to hear a case, but the execution is allowed to go forward, and then the case becomes moot because the applicant seeking the stay is no longer alive to challenge the conviction or death sentence. Justice Ginsburg frequently used the word dreadful to talk about death penalty cases, particularly these applications for stays of execution. In 2011, she said the review of pending executions was a dreadful part of the business. She said in 2018 at Columbia Law School, she said, every one of those death penalty cases is dreadful for me, especially the 11th hour stays. It's the last day and all the stops are pulled out. And then she added, one of the things about death cases is that most of these people have abysmal representation at trial. As they get closer to the execution date, their representation gets better. I think if that kind of representation were available in the first instance instead of the last, we wouldn't have any death sentences. And that really shows sort of her understanding of the big picture of of capital punishment and death penalty cases. It also connects back to the 2020 World Day Against the Death Penalty theme, which was access to counsel and the death penalty. And I'll have my colleagues post in the chat a link to a continuing legal education session we did last year for World Day Against the Death Penalty about access to counsel, specifically focusing on the United States, session run by a colleague of mine, Lisa Borden, who I think is here today as well. So that's the sort of one of the first things we know Justice Ginsburg would have encountered when she was first on the court. And one of the early cases early cases that came to the court about the death penalty was a case called Collins versus Collins. And this was February 1994. It wasn't a case that the court heard. It was a case the court decided not to hear in February of 1994. But what this case is really notable for is Justice Blackmun and his dissent from the denial of certiorari. So you recall that Justice Blackmun was the one who I referenced who had dissented in Furman, that case in 1972 that resulted in that de facto moratorium on the death penalty. And by this time, by 1994, Justice Ginsburg's first year on the court, he had done a 180. Justice Ginsburg was brand new to the court, and she faced a crossroads. She knew from Coker, her ACLU case, that Brennan and Marshall had staked out this absolutist position, saying that the death penalty in all cases is unconstitutional. And I'll just show you sort of the seminal text from the Justice Blackmun's opinion dissenting from the denial of certiorari in that case. So you can see these are probably words that would be familiar to you if you have followed the Supreme Court's death penalty jurisprudence. So I'll share that right now. And the first sentence is the opening sentence that rings in my ears. From this day forward, I no longer shall tinker with the machinery of death. So this is Justice Blackmun saying, I'm not going to play along with the assumption that in some cases the death penalty can be okay. I'm no longer going to play that game. So this is, in the justice's first term, this is what she saw, that some justices had staked out this absolutist position, which I tend to agree with, that the death penalty in all cases violates the Constitution. And so, it seems as though this really influenced Justice Ginsburg to be a part of the court when Justice Blackmun issued this dissent. She talked about this further in 2018. She says the category of cases that has given me tremendous anxiety since my first day on the court are the death penalty cases, because if I were queen, there would be no death penalty. I did make a choice that I would not do what Brennan and Marshall did and what Blackmun did. I'm part of a collegial bench, and I try as best I can to move the law in the right direction. But every one of those cases is dreadful for me. Again, that word dreadful. And then she said again in another interview, I had to make the decision, was I going to be like Brennan and Marshall, who took themselves out of the loop by dissenting in every case upholding the death penalty? There have been some good death penalty decisions. If I took myself out, I couldn't be any kind of contributor to those. And she said in another interview, I wanted room to be persuasive with the other justices. So she made a deliberate choice, probably very early on in her position, in her time at the court, to try to be this incremental voice to move the court in the right direction. Her first opinion with respect to the death penalty was also in her first term. It was in a case called Romano versus Oklahoma. We'll put a link to that in the chat. It was argued after Collins, so after Justice Blackmun issued his famous dissent. And she was, Justice Ginsburg was in the minority. She was in the dissent. It was a 5-4 decision. And we know that Justice Blackmun was the senior justice in the dissenting group. So it's probably the case that he assigned the dissent to Justice Ginsburg in her first year on the court. So Justice Blackmun probably wouldn't have been in a position to write that dissent because his dissent would go further based on what he had said in Collins. So the gist of the opinion in Romano, it's not like a huge blockbuster case, but at the sentencing stage, the district court had admitted evidence about the defendant's that the defendant had been sentenced to death already in a different matter. And this evidence came in because having a prior conviction of a violent felony would have been an aggravating factor, allowing the jury to sentence him to death. Subsequently, though, the state appellate court struck down that prior conviction. So the issue in front of the court was, did admitting that evidence create an unacceptable risk of the jury minimizing its role in the sentencing process? In other words, you could see jurors saying, well, yeah, we can sentence him to death because he's already he's already been sentenced to death. So like, we're not like adding anything. We don't need to really worry about the morality of it or whether it's right or wrong. He's already going to be sentenced to death. So yeah, let's just repeat what the other jury did. Chief Justice Rehnquist wrote for the majority and Justice Ginsburg wrote the dissent. And her conclusion for the dissenters was that there was this risk of minimizing the jury's sense of responsibility for determining whether the death penalty is appropriate. And in this case, it was really interesting because the defense counsel had agreed to stipulate to his conviction that he'd been convicted of a prior felony in a prior case. That was wise. But the trial court then admitted the judgment and sentence document, the actual document, and that document that was admitted into evidence said that he had been sentenced to death. So the jury got that information, didn't necessarily need to have that information. And that was the gist of that Romano case. I'm not going to talk about all of the justices' opinions on the death penalty. There are 3 additional cases that we'll put in the chat that have to do with jury-related issues and double jeopardy. And there were a couple of cases related to prosecutorial misconduct and violations of Brady versus Maryland, the obligation to disclose information to the defense. So we'll put those links in the chat as well. And now we'll speed ahead and talk about October term 2010, which is when I was clerking for the justice at the court. The first case I want to talk about is the case of Conic versus Thompson, and we'll put the link to that one in the chat as well. I'm keeping my colleagues busy with all of this. And this was another dissent by Justice Ginsburg, and it's likely we can, I can't disclose Chambers' secrets, but we can look at the makeup of the court at the time. And it's likely that Justice Ginsburg assigned this opinion to herself because this was the first year Justice Stevens wasn't on the court, so she would have been the senior most justice in the dissenting group. It was a 5-4 decision. And we also know that she read or summarized her dissent from the bench. And these are sort of objective indicators. She kept the opinion for herself. She summarized it from the bench that she believed the case was important. So what's the case about? It's another case about Brady violations, about prosecutorial misconduct and prosecutors withholding important evidence from the defense in death penalty cases. So John Thompson was the person who had been sentenced to death, and he brought a lawsuit in this case, Conic versus Thompson, against the district attorney, Harry Connick Sr. And I'll say, yes, that Harry Connick's father, in his official capacity under Section 1983 for failure to train his prosecutors about their obligations under Brady versus Maryland. And the background behind this was that 1 month before Thompson was scheduled to be executed, he had an investigator who randomly discovered an undisclosed piece of Brady evidence. It was a crime lab report that showed that this prior conviction, there was a mismatch on the blood. So he actually shouldn't have been had this prior conviction, and that prior conviction allowed him basically to be sentenced to death. Ultimately, John Thompson was retried, and he had access not only to that prior exhibit, that prior piece of evidence, but 10 other exhibits that had not been disclosed in his first murder trial. And he was found not guilty. The jury deliberated for just 35 minutes to make that finding of not guilty. So it seemed pretty clear that all of this additional evidence that hadn't been disclosed to him in his first trial was quite relevant, and he was exonerated. So he brought this suit to try to hold Harry Connick Sr. in his official capacity responsible for the Brady mishaps that happened in the case. And the jury agreed. The jury awarded John Thompson $14 million. And he had probably, because he had spent 14 years on death row, he had spent 18 years in prison, wrongfully convicted. And the Fifth Circuit affirmed the decision by an equally divided court. So that was the posture that the case went up to the US Supreme Court in 2010. And the question that the jury had to decide, and the jury decided in the affirmative, was whether non-disclosure of the evidence was caused by a policy, practice, or custom of the DA's office, or a deliberately indifferent failure to train prosecutors in the office. And so it's that latter part that was relevant on appeal. So the question the court was supposed to decide was, can a district attorney's office be held liable for failure to train based on a single Brady violation? And there's the relevant precedent here is a case called Canton versus Harris in 1989 that has this hypothetical, like when could there be liability for a single failure to train? And the hypothetical talked about armed police officers and fleeing suspects, and talks about, in this context, there's this obviousness of the need to train armed police officers about whether or not they should shoot fleeing suspects. And that obviousness can substitute for the pattern of violations you'd normally need, so that even if there's a one-off violation, it's obvious. And so you could have municipal liability in that case. The majority, and this is Justice Thomas, who writes for the majority, essentially says the district attorney's office, these are all lawyers. They know about the law. They can learn about the law. So it's not obvious that the DA's office needs to train them about the specific Brady violation here. So that's why under Canton versus Harris, the municipality can't be held liable and the jury verdict is struck down. So in other words, the court took away this $14 million jury verdict in John Thompson's favor. So what I want to do now, though, is show you a picture from my archives, and let me get my screen sharing up and running. So this is me with John Thompson. And I just want to add as a personal note that I feel really privileged to be working for the Advocates for Human Rights on death penalty work. A law clerk working at any court really rarely gets to know the people behind the cases. And my involvement with the Advocates for Human Rights and the World Coalition Against the Death Penalty has really given me some unusual opportunities that I'm just tremendously grateful for. I had the chance to meet and talk with John Thompson, who was the respondent in this case, at the World Coalition Against the Death Penalty's General Assembly a few years ago, and it was really a highlight. He was a really important voice for Witness to Innocence, which is a member of the World Coalition Against the Death Penalty. And my colleagues will post in the chat a blog post I did to learn, so you can learn a little bit more about his perspective and personal views on the case. And you can take a look at that there. And like many exonerees, including most recently Damon Thibodeau, who is represented by a local law firm here in Minneapolis, Frederickson and Byron, health matters cut John Thompson's life short. After spending so many years on death row, he had very few years experiencing freedom after being exonerated, and his death was a tragedy. So I just feel so grateful that I had the chance to meet him and talk with him and continue to be inspired by John Thompson before he died a few years ago. So it's just tremendous to me to have this chance, to have had this chance to have been part of Justice Ginsburg's chambers when she was authoring her dissent in the case, and then to really hear about and see and experience the reality behind it. And I was most impressed by his resilience, that he, although it was devastating for him to have lost at the Supreme Court, he had a really positive outlook, and it was just amazing to hear that from him. Justice Ginsburg's dissent, of course, disagreed with the majority's conclusion, and this is just a little excerpt of the dissent. Justice Ginsburg's focus was that the district attorney's office didn't understand the Brady obligations, that there was not just one prosecutor, but 4 different prosecutors had violated Brady. They had multiple opportunities to set the record straight and did not, and that the jury could have concluded that it was standard operating procedure within the office to ignore Brady. It wasn't just this momentary oversight, not just a one-off. She also pointed out that Brady violations are not easily detected. So prosecutors have an incentive to repeat this behavior unless there is municipal liability. This excerpt I like to highlight just because it mentions continuing legal education, which is what we're doing right now. And at the time of the trials, there was no continuing legal education requirement in Louisiana. So there was no incentive for the prosecutors to stay up to date with legal requirements, and Brady obligations change because of new Supreme Court precedents, because of new obligations. And I like the second sentence because it emphasizes Justice Ginsburg's unique use of language. Primary responsibility for keeping prosecutors au courant with the developments resided in the district attorney's office. And they circulated memoranda, but what the dissent points out is that oftentimes the information that was shared with the prosecutors was not accurate about Brady. So that was an important part of why Justice Ginsburg concluded that there should be municipal liability in this particular case. So that's a little bit about Conic versus Thompson. And unfortunately, that is now the precedent. That was the decision of the Supreme Court. And now I'll shift to talk about another case that was before the court during the term I clerked for Justice Ginsburg, and another opinion Justice Ginsburg authored. And this one has a little bit of a happier conclusion. Justice Ginsburg was writing for the majority in this case. And this is the case of Skinner versus Switzer. And to build off of what I talked about John Thompson, I want to introduce you to Sandrine George Skinner and Hank Skinner. Hank Skinner is the person on the right and Sandrine is on the left. And you see them together early on the left and more recently on the right. These are photos that Sandrine provided for me. And Sandrine and I both serve together on the steering committee of the World Coalition Against the Death Penalty. So this is, again, a thing that I treasure about my death penalty work is having been part of Justice Ginsburg's chambers when she was working on these cases. I now know the people behind the stories, and it really helps humanize what otherwise might seem like dry and esoteric matters before the court. So the case in Skinner versus Switzer, and we'll put that link in the chat if it's not already there, was a 6-3 decision, and Justice Ginsburg wrote for the majority. Hank Skinner had been sentenced to death for a triple murder, and he wanted to do DNA testing of evidence that the district attorney's office had in its custody in Texas. It was a procedural due process claim. He's like, I want to do this testing. Let me have access to this testing. And he filed a 1983 action. So the question, or there were 2 related questions posed to the court in this case, is there federal subject matter over Skinner's complaint? And is the claim cognizable under 1983? Should it be brought under 1983 or should it be brought in habeas? So, and again, I mentioned early on about the stays of execution and how stressful those can be for law clerks and the justices because everything's going on really quickly at the 11th hour. But I thought it was really helpful to get Sandrine's perspective on what it's like to be the spouse of someone who's on the verge of being executed. And here's what Sandrine told me when I reached out to her to get her insights on the case. She said, the wait with the legal procedures is pure torture. After SCOTUS granted him an unlimited stay of execution 25 minutes before the execution, which she referred to as torture, just watching the seconds tick away, it took the court another 3 months to decide they were actually taking the case. So they had issued the stay, but they hadn't granted certiorari yet. So that was also for, she said, for every Monday for 3 months, we waited for a reply. And every week the case was rescheduled for the following conference, knowing perfectly well if they denied the case, he was going to die in the next month or so with no other legal avenues to pursue. So it really helps to sort of humanize and think about the stress on the people who are at risk of being executed and their family members who are experiencing what's going on at the court. The case was argued 11 years ago, and Sandrine shared her experiences of being in the courtroom for oral argument. She said it was a very special experience. In fact, nothing compares to it or can aptly describe it. Watching the justices in their seats, I was immediately drawn to RBG because she looked so tiny in her huge armchair. One felt like picking her up like a wounded bird and placing her gently in a nest of cotton wool to keep her warm and safe. I remember feeling that very clearly. And then she adds, and then Rob, who is Hank's attorney, was about 5 minutes into his presentation, and Justice Ginsburg jumped right in, interrupted him, and asked several questions. And Sundry said, at first it worried me, but I quickly realized she wasn't declaring war on the case, but she was looking forward to a good legal challenge. But she added, emotionally, it was hell to look at these 9 judges knowing that Hank's life was in their hands. And then she said after the oral arguments, it was another form of torture waiting for the opinion and again, not knowing. She said they were pretty certain that they had the votes. But the day the opinion was released, she said she was in a steering committee meeting at the Paris bar. And she says, I remember the moment like it was yesterday and I'll never forget. And you can see how the matter has aged them, but I'll also show you, this isn't the steering committee meeting that Sandrine is referencing, but this is a subsequent steering committee meeting also at the Paris bar. You'll see I'm over on the left, Sandrine is over on the right, and you have the other members of the steering committee posing for one of these family portraits at the end of our steering committee meeting. That steering committee has really created relationships out of some of these cases that I was involved with at the court. So I will stop sharing my slides there and continue talking. So when Justice Ginsburg wrote for the court in the Skinner case, she first had to talk about the Rooker-Feldman doctrine, which I'm not going to go into, but she basically said that doctrine doesn't bar the claim here. And then she clarified that he's not challenging the prosecutor's conduct or the state court's denial of his applications. He's challenging the statute as construed by the state courts as violating procedural due process. And so that wouldn't invoke the Rooker-Feldman doctrine. But then under, like, should he be bringing the case under 1983 or under habeas? She says habeas is what a defendant uses when they're seeking immediate release or speedier release or challenging their conviction or their detention as unlawful. But in this case, Skinner doesn't know, and nor do we. We don't know what the evidence will show. He wants access to the evidence to be able to test it, but it could be that evidence is exculpatory, it could be inculpatory, or it could be inconclusive. He just wants access to testing it. So therefore, habeas isn't the right realm. The right way to bring this action is under 1983. So, like, not a blockbuster opinion, but something that really helped to advance the rights of somebody who is at imminent risk of execution. I asked Sandrine for an update about the case, and I heard back from her this morning. She said all of the DNA results have been available since August of 2013. So that's now 8 years that the DNA results have been available. And the Court of Criminal Appeals in Texas has not yet ruled whether the jury would have convicted him at the time of trial had those results been available to him. So they've been sitting on his appeal for 3.5 years. If they agree, then they can file a claim of actual innocence. But if they can't, then he'll probably get a new execution date. And if there aren't any constitutional issues they can raise on appeal, then they won't be able to bring any other issues in federal court. She says, I try not to look that far ahead, but we're both realistic about the risks and the fact that his life still hangs by a thread. She also added the pandemic has added immense stress on death row, while in solitary confinement, some prisoners were contaminated by guards who are not vaccinated or refused to wear a mask. She said visitation was suspended for a whole year, including legal visits, and now it's only resumed in a very restricted format. Sandrine lives in Paris as well, and so she will face the difficulty of international travel, but she's hoping to visit him early next year if she's allowed. So that's another case. Then there was another opinion I wanted to talk about briefly, which was it had its origins in the 2010 term, but was heard in the 2011 term, and it draws on some statements that Justice Ginsburg has made. She made a statement to the Associated Press in 2011. She said, people who are well represented at trial do not get the death penalty. I have yet to see a death case among the dozens coming to the Supreme Court on eve of execution stay applications in which the defendant was well represented at trial. The case I want to talk about is Maples versus Thomas, and we'll put a link to that in the chat. And this was a 7-2 decision. Justice Ginsburg wrote for the majority and Justices Scalia and Thomas dissented. The petition for certiorari was filed in July 2010, but the case wasn't granted until March of 2011. For those of you SCOTUS blog fans, this was a case that was held and relisted on that relist watch list that SCOTUS blog publishes. Above the Law referred to this case as Sullivan and Cromwell's mailroom of death. So this has pro bono implications for all of you. We could probably turn the CLE into an ethics CLE if we focused on the right things. And based on the breakdown of who was in the majority, Chief Justice Roberts would have assigned the case to Justice Ginsburg. The general rule that was at issue in Maples was that a federal court won't consider a state prisoner's habeas claim when the state court has decided not to address the claims because of some procedural bar, and if that judgment from the state court rests on independent and adequate state procedural grounds. So normally, if there's a state reason, like we didn't consider this and here's why, and this is a state rule that we're not going to do this, then the federal courts don't give the defendant another bite at the apple. There's an exception though if there's cause and actual prejudice. So that's what we care about, whether Corey Maples in this case had cause and actual prejudice. So here's the background of the case. It's the case arising in Alabama, where again, my colleague Lisa Borden is an expert about Alabama law. Alabama is kind of famous for having inexperienced trial lawyers in its death penalty cases. And that was the case for Corey Maples. So he had been sentenced to death, had inexperienced trial lawyers, and then it was in state post-conviction relief proceedings. And there were, of course, as Lisa's saying, she wrote one of the amicus briefs in the case. So in state post-conviction relief proceedings, they were going to raise ineffective assistance of counsel, of course, among other issues. And in the post-conviction relief proceedings, he had pro bono attorneys from New York who worked at Sullivan and Cromwell. And they had submitted that petition to the trial court. They were waiting to hear back on the petition. And meanwhile, the two attorneys working on the case at Sullivan and Cromwell left the firm and didn't tell Maples and didn't seek leave to withdraw, nor did they notify the local counsel of their leaving the firm. And they were also conflicted out of doing further representation because of what their new jobs were. One was clerking for a federal judge, for example. So 1 year later, the trial court denied the petition for relief, and notices of that order went to the law firm mailroom, got them, returned them unopened. And so the trial clerk got those back, and then the time to appeal had run out. So this is state court provision, time ran out, you didn't submit your appeal. And so the federal habeas court said procedurally defaulted, sorry. And so Justice Ginsburg, writing for the court, said in these circumstances, there was cause to excuse the procedural default. The cause was that Corey Maples had been abandoned by counsel. His counsel had just flown the coop without telling him. There's discussion in the opinion, something that's really important in death penalty issues is Alabama's eligibility requirements for lawyers to represent indigent capital defendants. They don't need to have any experience in capital cases, and they're also undercompensated. Before 1999, they were paid $20 an hour to prepare for the case and $40 an hour for their time in court. And for fees, they were capped at $1,000. Now, even at the time of the decision in 2012, the fee had been bumped up to $70 an hour. So Alabama is also one of the few states not to guarantee representation in post-conviction proceedings in capital cases, which is why he had pro bono counsel for these proceedings at the trial court. There are, of course, now organizations that really help to try to improve the representation of capital defendants in Alabama and other places, including the Equal Justice Initiative, the Innocence Project. But the Maples case is one that really highlights what can happen with ineffective assistance of counsel, and particularly if there's pro bono assistance and the pro bono attorneys mess up. The local counsel that had them, that was helping out with the case, told the Sullivan and Cromwell attorneys that he couldn't deal with the substantive issues of the case. He would only be local counsel for the purpose of allowing them to appear pro hoc vice on behalf of Maples. And because in the court documents, counsel were listed, Maples himself did not have a right to receive his own notice of proceeding. So he was actually prohibited from getting his own notice in his own case. So the case turned out the right way. Seems like a horrible injustice. Justice Ginsburg authored the opinion. It's a really good read to sort of open your eyes about the situation of capital defense in Alabama as well. So I highly recommend that. So that was 2012. Those are the only cases that I'm going to talk about, but I did want to reference that in 2015, There's a case before the court called Glossop versus Gross. The Advocates for Human Rights with some pro bono support submitted an amicus brief in that case. And Justice Ginsburg or Justice Breyer wrote a really long dissent questioning the constitutionality of the death penalty, going back to Brennan, Marshall, and Blackmun, who had reached that conclusion. Didn't go all the way, but suggested that the death penalty is unconstitutional. Justice Ginsburg joined that dissent in Glossop versus Gross. So I think it shows that she was stepping more toward that more extreme position. She also joined Justice Breyer in Barr versus Lee, which was a decision in July 2020. This was a case involving the resumption of federal executions, which we saw during the last few months of the previous administration. The majority in a per curiam had allowed the executions to go forward. And an interesting note, this case arose out of the Seventh Circuit because the federal execution chambers in Indiana and Justice Ginsburg's replacement on the court was part of the unanimous 3-judge panel that allowed the execution to proceed. So a little bit of a touch point there. Some additional public statements the justice had made on the death penalty. She was asked at the University of Pennsylvania in 2018 whether she had ever presided over a case in which no legal interpretation could lead to a just outcome. And her response was death penalty cases. In 2011, she was asked what she would like to accomplish in her remaining years on the court. She said, I would probably go back to the day when the Supreme Court said the death penalty could not be administered with an even hand, that is to say in 1974, but that's not likely to be an opportunity for me. So clearly death penalty was important to the justice. And I think sort of in conclusion about her jurisprudence, I think with respect to the death penalty, she accomplished what she set out to do. She was able to influence the court. She helped shape its death penalty jurisprudence in a positive direction. And when the court took the wrong direction, she was vocal in dissent. And in public settings, she also brought attention to the issue and the injustices involved with the application of the death penalty. And as with Justice Blackmun, I think over time, she seemed more and more convinced that the death penalty was always wrong. But she wanted to contribute to the court's collegiality and she wanted to have a voice in how every death penalty case came out. So that's sort of my wrap up of talking about Justice Ginsburg. I wanted to talk for a few minutes a little about the Advocates for Human Rights and its work on the death penalty. As I mentioned before, I've had the chance through our work on the death penalty to collaborate with folks at Witness to Innocence, with Sandrine George Skinner, who's on the steering committee of the World Coalition Against the Death Penalty. But one of the things that's really important about our work at the Advocates for Human Rights on the death penalty is that we're able to leverage our pro bono support to ensure that United Nations mechanisms put pressure on governments to abolish the death penalty. Going back to my role as a microphone, when we have coalition members who want to be heard, who want to use the United Nations to press their governments to abolish the death penalty, my role is to step in and help amplify their voices. Sometimes I'm a microphone, sometimes I'm a megaphone. We also do advocacy with the United Nations about the death penalty in the United States. And we're putting some links to in the chat about that if you want to learn more about how we're pressing the United States to abolish the death penalty, including with the current administration. We're also involved with other high-level debates at the United Nations. For example, earlier this year, there was a high-level panel on the death penalty and whether it has a deterrent effect. So we contributed to that debate at the Human Rights Council. There's a resolution before the Human Rights Council right now. It'll be voted on probably tomorrow with respect to the death penalty. So we're actively monitoring those proceedings and we're quite involved with making written statements and oral statements on the floor of the Human Rights Council about these broader death penalty issues. We also are involved with reporting to the United Nations treaty bodies on death penalty issues. And I want to give you an example of how our advocacy, how our work with the support of our pro bono partners has had an effect. So I'm going to jump to an example and I'll tie it to this year's World Day Against the Death Penalty theme, which has to do with women sentenced to death or executed. And I'll share my screen and walk through this example for you. So the Committee on the Elimination of all Forms of Discrimination Against Women reviews countries and their compliance with the Convention on the Elimination of All Forms of Discrimination Against Women. And we knew that in July of last year, they were going to prepare to sort of set the agenda for a review of South Sudan. the newest country in the world. And what we did in collaboration with the World Coalition Against the Death Penalty is submitted a report in June of last year identifying some issues related to the death penalty. Now, the Committee on the Elimination of Discrimination Against Women doesn't always talk about the death penalty. It doesn't always come to mind on the part of the committee experts, but we wanted to make sure they paid attention to it because we knew there were women on death row in South Sudan. We didn't know how many, but we knew that there were some important issues of concern, and we wanted to see if we could get the committee experts to press South Sudan to abolish the death penalty and to take into account the circumstances of women who were sentenced to death. So to look at some of those issues of discrimination, for example, that we're all talking about in the lead up to World Day Against the Death Penalty on Sunday. So we submitted this report in June of last year to try to help the committee set its agenda. And then the committee published what's called its list of issues. They published it in July of last year, their list of issues and questions for the government of South Sudan, again, teeing things up for the review. That review is going to happen next month. And in that list of issues and questions, normally they don't mention the death penalty, but we gave them a little nudge. And so what we saw in their section on access to justice at the very end is the relevant text, and I'll blow that up on the screen, is they wanted to receive information about any provisions in place to ensure women are able to opt out of proceedings before customary courts, because customary courts in South Sudan are allowed to sentence people to death, and also provide information about women who have been sentenced to death or executed, including disaggregation by offense, sentence, age, location, and number, and age of defendant children. And this is information we didn't have. So it was great to have the committee experts come back and ask the government to say, hey, share this information, because we didn't have access to it. Our World Coalition partners didn't have access to it. So we got these experts in Geneva to ask for that information. And because of the way the procedure works, the government has to submit a written response. So they submitted this response. It's not a complete response, but they at least gave us some basic information about women sentenced to death. They asserted that women can opt out of the customary courts. And then we have the numbers, official records now, of that there are 10 women under sentence of death in South Sudan. So that's at least a starting point. And what we'll be doing, what we've done since then, and we're going to put these reports in the chat if they're not already there. So we submitted a second report to the committee to encourage them to press the government to make additional recommendations relating to women and the death penalty, raising some of the issues of discrimination. You'll see that all of the women on death row in South Sudan have been convicted of murder. And in most cases, we don't know the circumstances of these cases, but in most cases, women are sentenced to death for murder because they have murdered an intimate partner, typically in a context of gender-based violence. And typically after prolonged gender-based violence, it'll be an act of self-defense. In some cases, it's a woman who, or a girl who has been subjected to forced marriage. And so there are a lot of grave circumstances to take into account. It's also particularly of concern in a country like South Sudan that has, in some circumstances, a mandatory death penalty, where the court can't take into account the gendered aspects of why a woman may have killed her abuser. So we are able to point to direct effects of our advocacy, that the Committee on the Elimination of Discrimination Against Women is actually paying attention to these issues. And our advocacy is having an effect. What I'll add here is that we are involved in other issues with respect to our partner organizations through the World Coalition Against the Death Penalty. We're helping build the capacity of the more than 160 members of the World Coalition to engage in advocacy at the United Nations. This morning, we had a virtual side event with partners from Tanzania. We'll put a couple links in the chat about our work in Tanzania, the Caribbean, and we've paired those partners in the World Coalition up with pro bono teams to help them prepare reports. We help them do advocacy, again, so their voices are heard. We're the microphone. And we have a victory this year that we're celebrating. We've done a lot of advocacy with a World Coalition partner organization in Sierra Leone, and that advocacy happened earlier this year. And in July of this year, the government of Sierra Leone abolished the death penalty. So we're really celebrating now. We delivered a statement on the floor of the Human Rights Council last week, congratulating the government of Sierra Leone and pressing the government to uphold its word and take those additional steps to solidify its rejection of the death penalty. So it's great to be able to see that kind of progress as some of the fruits of our collaborations through the World Coalition and with pro bono partners. We can always use more pro bono support. We want to ensure every UN body has information at its fingertips when they're reviewing countries that still have the death penalty. And we want to ensure that every coalition member has the support it needs to do fact-finding, engage in UN advocacy. So you can play a role in helping us do that work. So That's my wrap up. I want to thank you all for attending this free CLE. If you want to support our work to abolish the death penalty, you can sign up to volunteer with us, but you can also donate to support our work because we do need funds to help that happen. You can text death penalty, all one word with no spaces, to 44321, or click the link in the chat to give. And I want to thank you for joining us today. I hope you'll join some of the other events we have in the series going on for the next few months. And I want you to thank all of you for being part of the human rights movement. Thanks so much.